Assalamualaikum warahmatullahi ta'ala wabarakatuhu, and good morning everyone. We are the fourth reporter. By the way, my name is Alea Jihad Salik and my co-reporters are Imba Norbaina, Kamenza Hadeya, and Kangguan Angelina. So our topic for today is all about legal foundation. Now, before we start our main discussion, let me first show you or introduce you our learning objectives. Now, this is our learning objectives. At the end of the lesson, the students will able to A. Define what is law, B. Explore the sources of Philippine educational jurisprudence, and C. Understand the Philippine education system's legal basis. Now, these are our contents. So, before we start on defining the law, let me give you some very short discussion about the legal foundation. Now, when we say legal foundation, it is the basis for admitting testimony or evidence into evidence. Now, when we say legal foundation of education, it is the laws governing students' admissions in public, private schools, colleges, and even universities. Now, what is law? I know all of you or all of us are familiar with the term law. So, law is the system of rules which a particular country or community recognizes as regulating the actions of its members and which it may enforce by the imposition of penalties. Meaning, it is a set of rules that are created and are enforceable by governmental institutions or social to regulate behavior. So, with its precise definition, a matter of long-standing debate, it has been variously described as a science and as the art of justice. Now, to make you understand what is law, it is an instrument which regulates human conduct or behavior, such as from a simple words, justice, morality, reason, order, and righteous from the point of view of the society as well as legislature. So now you know what law is. Let me discuss the definition and nature of law. Now, the law follows certain practices and customs to deal with crime, trades, social relations, property, finance, and more. The law controlled and enforced by the governing authority. Now, the term law is commonly used for three things. First, it is used to make legal orders, meaning it represents the rule of adjustments of relationship and order conduct by systematic application of a force organized political society. Second, law means the entire legal body which exists in one politically organized society. Third, the use of law means official control of politically organized society. So, this gives rise to the real administrations of justice and official content to guide judicial action. So now let us explore in detail the various definitions of law which also defined by different authors. So as you can see, it is very difficult to define the term law. Many jurists attempted to define the term law. So for the purpose of clarity, some of the definitions given by jurists in different periods are categorized. First is the idealistic definition of law. Second, positivist or positivism definition of law. Third, realist definition of law. So let us proceed to the first definition, the idealistic definition of law. So according to John W. Salmond, The law might be defined as the body of principles recognized and applied by the state in the administration of justice. Meaning, the law is a body of official rules and regulations, generally found in constitutions, legislation, judicial opinions, and the like, that is used to govern a society and to control the behavior of its members. Now, some of the authors criticize Salmon in defining law, but despite of all criticism, Salmon's definition is considered as workable definition. Now, according to John Chipman Gray, the law of the state or of any organized body of men is composed of the rules which the courts, meaning the law will be organized only that which is, or in the term that is the judicial organ of the body lays down for the determination of legal rights and duties. The second definition of law, the positivist or the positivism definition of law. Now, according to John Austen, 1790 to 1859, an English jurist expounded that concept of analytical positivism, making a law as command of sovereign backed by sanction. Now, Austen developed logically a structure of legal system in which he gave no place to values, morality, idealism, and justice. So, according to Austen, a law in the strict sense is a general command of the sovereign individual or the sovereign body, meaning it is issued to those in subjectivity and enforced by the physical power of the state. The last definition of law, the realist definition of law. So it is a branch of sociological school. It studies law as it is in its actual working and effects. So it has been summed up by its exponent Professor K. Llewellyn as ferment. Now, according to George Goroch, the neo-realistic school represents a violent reactions against the dominantly theological and moralizing orientation of sociological jurisprudence. So now let us proceed to the nature of law. So what is the nature of law? These questions has occupied center stage jurisprudence and philosophy of law in the modern era and has been the central occupation of contemporary analytic jurisprudence. So this entry in the legal theory lexicon aims to give an overview of what is law debate. So now, historically, the answer to the question, what is law, is thought to have two competing answers. The first answer is the classical answer. The classical answer is provided by natural law theory, which is frequently characterized as asserting that there is an essential relationship between morality, law, and justice. The second answer is the modern answer. The modern answer is provided by legal positivism, which was developed by John Austen, as I mentioned earlier, asserted that law is the command of the sovereign backed by the threat of punishment. Now let us proceed to the typologies of law. We all know that every state and country has its own legal system, right? So there are many different branches of law, including corporate law, property and taxation law through to media, environmental health, and international law. Now, all types of law have far-reaching effects and help to shape politics, economics, and society in numerous ways. The first type of law, the administrative law. So, administrative law is an area of law that you will need to rely on if you wish to challenge the decision or action of a government official, department, or authority. So, meaning, the administrative law may also apply when the person whose decision you wish to challenge is not a government officer but is exercising as public power. Let us say, for example, a power granted to a person by a statutes. Now, the decisions or actions governed by administrative law are called administrative decisions. Second type of law, the constitutional law, which is, it is the body of law which defines the relationships of different entities within a state, namely the executive, the legislator, and even the judiciary. Let us say, for example, the right to travel across states line, the right to marry, or the right to raise children. Now, the third types of law, consumer law. Consumer law covers national laws guaranteeing consumer rights when buying goods and services. Let's just say, for example, you buy a toaster but find a week later. So when you try to use it for the first time, that it won't turn on and the bread won't stay down. So the toaster is not of satisfactory quality. So the under the act, because you are, so this example is under the act of Consumer Act. It is because you had the faulty toaster for fewer than 30 days, you are entitled to reject it for a full refund so you can return it to the shop. So because the fault is obvious, there is no need for further testing and the trader must agree to provide a refund. The fourth types of law, the contract law. Contract law encompasses any laws or regulations directed toward enforcing certain promises. So in Australia, contract law is primarily regulated by the common law, but increasingly statutes are supplementing the common law of contract, particularly in relation to consumer protection. Now let us say, for example, John tells Dan that he will pay Dan $100. So if Dan paints his car and that Dan should show acceptance of the offer by the act of painting the car, Dan accepts by painting the car. Bilateral contract, a person accepts an offer by promising to the requested act. So that is contract act. Now the fifth types of law, the criminal law. Criminal law refers to a body of laws that applies to criminal acts. The main theories for criminal law includes to deter crime, to reform the perpetrator, to provide retribution for the act, and to prevent further crimes. Now, there are two types of criminal laws, the misdemeanors and felonies. So, when we say misdemeanors, misdemeanors are less serious than felonies and carry lighter penalties. So, typically, such penalties may include less than a year in jail, community service, fines, rehabilitation, or probation. While the felonies, on the other hand, come with at least a year and sometimes decades or even a lifetime in prison. Now, the sixth types of law, the family law. It is the branch of law that deals with matters relating to the family, for example, divorce or child custody. Now, the last type of law is the tort law. So, what do you mean by tort? As it is a civil right of action arising independently of contract, restitution, crime, or equity. Now, tort serves to protect a person's interest in his or her bodily security, tangible property, financial resources, or reputation. Meaning, unlawful interference with one of these interests is redressable by an actions for damages, and potential interference may be prevented by injunction. So, the law of torts aims to restore the injured person to the position he or she was in before the tort was committed. So, now let me give you an example. A janitor has a duty to put up a wet floor sign after mopping. If he or she fails to put up the sign and someone falls and injures themselves, then a negligence tort case may be filed. Now let me give you a second example. Examples are, which includes car accidents, bicycle accidents, and medical malpractice. Now let us proceed to the second reporter, Miss Imba Norbaina.
A pleasant morning, everyone. I am Narbina Imba from BS Ed 2A. So, I'm going to discuss the sources of Philippine educational jurisprudence. The Philippines educational jurisprudence is hereby declare the policy of state of to protect and promote the right of all citizens to quality basic education and to make such as education accessible to all by providing all Filipino children a free and compulsory education in the elementary level and free education in the high school level. Additionally, understanding the legal system lays the groundwork for learning how to apply the fundamentals of judicial, administrative, and constitutional law in educational context. Moreover, both at the federal and state levels, the courts have had a significant impact on the growth of the education system. The main sources of Philippine educational jurisprudence is the number one, Constitution, the fundamental and supreme law of the land. Constitutional education, the state shall provide free and compulsory education of all children in the age group of 6 to 14 years as a fundamental right in such a manner as the state may by law determine. 1987 Republic of the Philippines Article 14 Section 1, the state should protect and promote the right of all citizens to quality education at all levels and should take appropriate steps to make such education accessible to all. In this section, they want to promote an education that is free to all the students and should be accessible to all citizens. And also this section explain why we have this kind of quotation, which is the education is not a privilege, it is a right. So the section 2 states should number 1 establish, maintain, and support a complete and integrated system of education relevant to the needs of the people and society. Number 2, establish and maintain a system of free public education in the elementary and high school levels without limiting the natural right of parents to rear their children. Elementary education is compulsory for all children of school age. So number 3, establish and maintain a system of scholarship, grants, student loan programs, subsidies, and other incentives which should be available to deserving students in both public and private schools, especially to the underprivileged. Number 4, encourage non-formal, informal, and indigenous learning systems as well as self-learning, independent, and out-of-school study programs, particularly those that respond to community needs. And number 5, provide adult citizens, the disabled, and out-of-school youth with training in civics, vocational efficiency, and other skills. So in this section, it is explains that in the Philippines, the mission of non-formal education is to equip Filipino what is cerebral knowledge, skills, attitudes, and values that will able to him or her to think critically and creatively, humanely, and improving of quality innovatively his or her life and that of his or her family, community, country with its literacy programs and fundamental development projects and aim to minimize the number of illiterate out of school youth and adults, as well as continue education from vocational training to adult training classes from family planning sessions to cultural and leadership workshops for community leaders. This system of education encompasses a wide range of activities. The number two sources of Philippine educational jurisprudence is statutes. It include acts of Congress, municipal charters, municipal legislation, courts rules, administrative rules, and orders, legislative rules, and presidential insurances. Statutes is a positive statement of legal rules enacted by legislative. Republic Act number 10533. Act refers to Republic Act number 10533 entitled An Act Enhancing the Philippine Basic Education System by Strengthening its curriculum and increasing the numbers of years for basic education, appropriating funds therefore and for other purposes, otherwise known as the Enhanced Basic Education Act of 2013. In a historic moment for advocates of education equity, President Benigno Aquino III approved Republic Act 10533, signing into law the K-12 program on May 15, 2013. Education Act of 1982, this was an act providing for the establishment and maintenance of an integrated system of education. In accordance with Section 2, this act shall apply to and govern both formal and non-formal system in public and private schools in all levels of the entire educational system. Republic Act 10157, it is also known as the Kindergarten Educational Act, which means kindergarten education, the first stage of compulsory and mandatory. Republic Act 10627, the Anti-Bullying Act of 2013, this law is one of the first anti-bullying laws in the world. The number three of sources of Philippine educational jurisprudence is case law or jurisprudence. Case law is a law that is based on judicial decisions rather than law based on constitutions, statutes, or regulations. Also, the word jurisprudence derives from the Latin term jurisprudentia, which means the study, knowledge, or science of law. Jurisprudence is the body of case law on particular topic. A case is a decision rendered by a judge or justice of the peace after hearing or all of the sides to a dispute, and the structure of modern format. Judicial decisions follow a standard format, the style of cause containing the names of the parties.
Assalamualaikum and good morning everyone. I am Hadeya Kamenza and my topic is all about regulatory laws, ordinance, legal opinion, and resolution. So, regulatory laws refers to a law promulgated by an executive branch agency under a delegation from a legislature. So, regulatory law contrasts to statutory law promulgated by judicial branch or the legislative branch, and common case law promulgated by the judicial branch. So the law that governs conduct of administrative agencies, both promulgation of regulation and adjudication of application or disputes, and judicial review of agency decisions is called administrative law. So administrative law is promulgated by the legislature land refined by judicial common law for governing agencies. The administrative agencies are to create procedures, applications, licenses, appeals, and one other important thing called decision making. Administrative Procedure Act is responsible for all the federal agency policies. Some states have started following the policies through law on regulation. So the second one, we have the ordinance, a law set forth by a governmental authority, specifically a municipal regulation. Ordinance applies to an order governing some detail of procedure or conduct enforced by a limited authority such as a municipality. An ordinance is enacted by the local legislative council authorizing the local chief executive in behalf of the LGU to exercise the power of eminent domain or pursue expropriation proceedings over a particular private property. Well, the legal opinion in law, a legal opinion is in certain jurisdictions a written explanation by a judge or group of judges that accompanies an order or ruling in a case, laying out the rationale and legal principles for the ruling. So, a legal opinion is an opinion expressing legal conclusions about and or legal analysis of a transaction or matter. The last one, we have the resolution. So from the word itself, resolution, it is a finding an answer to a certain problem. So you are solving, or it is the answer to a certain problem.
Assalamualaikum warahmatullahi ta'ala wabarakatuh. So I am Angelina Kangguan Bagundang, Bachelor of Secondary Education, major in English. So let's proceed to the legal underpinnings of Philippine education. Okay, so educational structure. So the 1987 Constitution, Article 14, Section 1, state shall protect and promote the right of all citizens to quality education at all levels, ensure appropriate step to make such education accessible to all. Education has curriculum and instruction to consider for the teachers, students to adapt to it. So knowing the structure, policies, curriculum, and instruction under the legal underpinnings Philippine education will enable us to have a brighter future and enhance our patriotism as a citizens of the Philippines. It simply states here that every student has the right to have a quality of education, whether it is in a public or private. So it is which I call the K-12 curriculum, where 6 years from primary schools and 6 years to secondary, and 4 years in a college. So, but these 4 years, it is no longer to required by the government to attain by all the students, because it is not all the students can afford and support the 4 years college education. So after this, a student pursue higher education. It includes higher degree, master degree, doctoral of medicine, and juris doctor and PD or PhD. So why K-12 implemented? So K-12 implemented to build and brighten up future for the nations of student as a professional and individual and good quality of being citizens. Section 2. This state shall establish, maintain, and support a complete, educate, and integrated system of education relevant to the need of the people in society. So, example in this section 2, like a building, a school providing financial assistance to facilitate and to support and to be used construction of school. Section 2.2, establish the maintained system of free public education in the elementary and high school levels without limiting the natural rights of parents to their children. So elementary education is compulsory for all children of school age. So this stated that the governments of First Republic education from elementary to secondary is without the limiting the rights of parents to educate their children. So in addition, the student need to finish their elementary schools and explore to cold step into secondary education. Establish and maintain a system of scholarship grants, student loan programs, subsidies, and other incentive which shall be available to deserving student in both public and private school, especially to the underprivileged. So in this section, we discuss that financial offered by the state in deserving student. So offered full scholarship, if I'm not mistaken. So next, section 4.4. Encourage non-informal indigenous learning system as well as self-learning, independent and out-of-school study programs, particularly those that respond to community needs. So section 4.4, under section 2, the government encouraging indigenous people out of social youth to have not simply studied formal in school, so to have not graduated simply because they have a community needs. So for example, the elderly who have not studied properly at their age, and those people has a disability or disabilities. Okay, so let's proceed to the education policy. So education policy consists of the principles and policy decisions that influence the field of education, as well as the collection of laws and rules that govern the operation of education system. So, for example of policies, the child-friendly school system. So in this education policy, they need of child-friendly schools and the desired and outcomes for the children as follows: to be aware of their rights and to be able to protect them themselves. So in this field, this focuses on how people learn and the best ways to educate themselves. So when we say curriculum instruction, it is a field within the education which seeks to research, develop, and implement curriculum changes that is increase learner achievement in the educational settings. So curriculum is what teacher teach, and instruction is something that someone tells you to do. So in simple meaning, curriculum is what teacher teach. This is serve as the guide to instruction. So for example, in curriculum is our assignment or lessons. So in instruction, it is the way we teach the curriculum for learning, and it is someone that someone tells you to do. So that's all for my report. Thank you for listening.